Okay, hello everyone. How are you? My name is Jessica Gimble with Magna Legal Services, and today we are presenting the strategies for mitigating nuclear verdicts, CLE. There's been a lot of work put into this presentation, and it is absolutely interesting. With me today, I have Magna's own Dr. Rachel York Colangelo, who is our Managing Director of Jury Research, and also Karen Lilling and Richard Montes of Morrow, Lilling, and Naparty, who are going to be presenting. Just some housekeeping really quick. This is CLE approved, so you will see some polling questions launched throughout the duration of the CLE. Kindly select the best answer so we know that you are there, and we will issue a certificate of attendance after the CLE. So with that, I will turn it over to Dr. Rachel York Colangelo.
Thank you so much, Jessica. Thanks everybody for joining us this afternoon. It looks like we have a great crowd and we're very excited to present this material to you all. I think that it's a very timely topic. It's a topic that is the source of much discussion around trial teams that my colleagues and I are working with. We have a lot of material to cover. So I'm going to dive right in. I'm going to sort of introduce the topic and then turn it over to Karen and Richard. They have brought a lot of the substance to this presentation and have done a lot of research and work in this area that I'm anxious for them to share with you all. So I'm going to go ahead and pull up our slides and kind of talk about why are we focusing today on anchoring damages as a strategy for mitigating nuclear verdicts. Now, this likely goes without saying. I suspect that you are all on today's webinar because you recognize the proliferation of nuclear verdicts in all different types of cases around the country. This trend started even pre-pandemic. If you look at the numbers, these nuclear verdicts really started to pick up and have increased exponentially since about 2005. So this is not a new trend. This has been going on for some time. I've listed here just a few examples of verdicts that we consider nuclear verdicts. What is noteworthy about some of the examples here are that these are numbers awarded to a single plaintiff, or in some instances were cases where everyone involved thought that this should be a defense verdict, and it results instead in tens of millions of dollars being awarded. So we know that nuclear verdicts are becoming a problem. And one of the questions that we're getting is why? Why are we seeing these huge numbers from juries around the country? We know that there are a few accelerants, so to speak, that are driving up these numbers. I'm not going to go into detail about all of these. There are a number of issues that we've sort of recognized on Magna's end as contributors or these accelerants. One, I think, needs to be recognized, that is the plaintiff's bar really pushing the boundaries of reptile tactics and using reptilian strategies in a variety of types of cases to get jurors feeling fearful, angry, and fired up. And that sense of juror anger and emotion combined with anti-corporate bias in a lot of instances is a recipe for large numbers. Jurors are becoming punitive in a lot of cases, even when punitive damages are not on the table. That is the reason behind some of these large numbers. But one of the accelerants that we've identified with data, both in our own jury research as well as in empirical academic research, is the lack of counterfigures offered by defendants. So even when liability is contested and the defense is focused on liability, when the plaintiff is putting out a huge damages request, that becomes what we call an anchor, the topic of this presentation. Jurors' minds get anchored on that very large number. And in the absence of a low anchor, what they tend to do is start high and work their way down to something that perhaps they, the jury, feel is more reasonable. We're going to get into this a little bit more in the second half of this presentation, but the failure of defendants to address plaintiffs' numbers is one of the key reasons that we are seeing larger than necessary damages in a variety of cases. So I just wanted to kind of flag the traditional approaches to damages, that the plaintiff obviously is focused on the money. That is the reason they bring these cases. That is their end goal, is yes, they've got to convince a jury of liability, but they also want the biggest number they can get. The defense, on the other hand, is often more focused and spends a lot more time on challenging liability through arguments, for example, about standard of care, negligence, or causation. And discussions of damages and how to treat damages are often left until the last minute. It can be even a game time decision the night before a closing, where the team is trying to decide, what are we going to do about damages? Do we address it? Do we say it's a zero because we have no liability? Do we put forth a counterfigure, and what is that counterfigure? That is often decided, as I said, at the very last minute. There are concerns over a jury's potential perception of a defendant denying liability, putting forth a counterfigure or a low anchor. The concern is that we lose credibility on our liability defenses if we, quote unquote, offer money. Now, I will say that there are some mock jurors who do react that way, and they say, well, I think the defendant essentially offered something, and so I decided to go ahead and give this plaintiff something. However, not all jurors feel that way, and with the right approach and addressing damages head on, jurors can be made to understand that this is not an offer, that while we deny liability, we also need to address damages. Often the decision about whether we do or do not offer an alternative figure as a defendant kind of rests on a spectrum that we've identified here of, if we feel that the likelihood of a defense verdict is good, we have good liability defenses, we feel very strong about that, then the tendency is not to offer an alternative damages figure, because we don't want to cut against that strong liability defense by talking numbers. On the other end of that spectrum is when we feel that the plaintiff has a very good shot of winning the case, that we think our liability defenses are not going to resonate necessarily with the jury, then we do want to offer numbers. We're here to talk today about changing that approach, changing the nature of the game. And to talk about that new approach, I want to turn the floor over to Karen first. So Karen, I will turn it to you and let you take it from here.
Thank you, Rachel, and good afternoon, everyone. And thank you, Rachel, for advancing the slides. I'll do that as we go along. As Rachel pointed out, conventional wisdom has always allowed the plaintiff to anchor the value of the case, and damages have largely been unchecked by the defense. Traditionally, defendants allow the plaintiff to develop the story surrounding damages, and as Rachel pointed out, the defense focuses on challenging liability. And conventional wisdom has always told us that if the defense discusses damages, it's either, as again, Rachel pointed out, a concession of liability or the setting of a floor. But what we would urge is that rather than see it as setting a floor, not addressing damages is to permit an unlimited ceiling. Without evidence and arguments to chip away at the plaintiff's numbers, both jurors and courts will have no ability to award something less. Not to mention, and I think it's also important to stress, that an aggressive defense on damages is the best way to arrive at the most favorable number during any mediation. Rachel, if you can advance the slide. The advantages of an aggressive defense on, the advantages of an aggressive damages defense are that it negates one of the greatest reasons for the rise in escalating awards. And that is the plaintiff's unfettered anchoring of the jury or trial judge or mediator. The plaintiffs throw out numbers knowing that they are extreme, and people react to those numbers by either adopting them wholesale, or even if scaling them back, they are only scaled back off an already wildly exorbitant number. Moreover, taking an aggressive approach better postures the case to the extent that it will be tried to verdict. Many assume much too early in the process that the case will never go to verdict, and therefore damages preparation is either lost or much too delayed. As defendants, we not only need to be thinking about credible damages experts early in the case, but we should also think about and leverage legal challenges in relation to the plaintiff's experts on damages. For example, a motion to preclude for a lack of expertise, or a motion to preclude for a lack of foundation. Plaintiffs' experts often make assumptions that are not based in the actual facts in the record. Challenge the types of evidence that arguably do not violate collateral source rules. How is the reasonable value of medical expenses defined? What types of evidence should be permissible, even in the face of those strict collateral source rules? All of this is an effort to anchor the value, provide negotiating points, and create potential appellate issues. Next slide, please. Sometimes actually an aggressive approach can lead to legislative changes. States like Michigan, Missouri, and recently Louisiana have passed statutes limiting past damages to the amounts paid. And one of the effects of limiting economic damages is that it can also have an impact on the perception and calculation of the value of both non-economic and punitive damages. Next slide, please. Now, discovery. Discovery is the time to start developing the information that is going to help you create your anchor. Develop what you believe the damages are going to be in the case, and do not wait for the plaintiff to tell you or send you their life care plan or economist report. You put that in the garbage anyway. One area that's particularly important, I do want to point out, is past meds. You want to recognize early that if they are going to try to use the size of the past meds against you by saying, look how high the past meds are, such that it's going to be an impediment to resolve the case. If they're going to try to use the size of the past lien against you, then start going through the lien and find out whether there are legal arguments you can make to oppose it. Ask yourself, are you in a bill paid kind of a state? Can you make an argument about the reasonable value of the lien? Is this lien something at the end of the day that would be negotiable? Bring some practical reality to the process. In terms of the selection of experts, why choose a conventional life care planner? Why not a healthcare economist or nurse case manager? Why not have one expert to address medical needs and another better qualified to address actual costs? How about a trust and estates expert or an actual benefits expert for purposes of mediation? Target specific items of damages in the life care plan. Ask yourself, what's the driver? Is it home care? Is it facility care? Is it future surgeries? What expert and arguments would be best to combat that particular component? And spend time uncovering the inconsistencies in the proposed life care plan. Spend time on uncovering the plaintiff's pre-existing condition. All of this goes to anchoring the value. Next slide, please. I think the underlying theme here, if it's not clear already, is don't wait. Don't wait. We know as defendants, particularly experienced defense counsel, very early on, and can anticipate where the plaintiff is going. We don't need the life care plan to defend. We should start setting the anchor ourselves and early. We can identify the main components of damages. We can set up damages models. And all of this, in this way, the claims person is able to understand the value of the case sooner. And the defense attorney is able to ascertain what discovery is still needed and what foundation needs to be laid. And in terms of medical expenses specifically, it is best to identify as early as possible what the plaintiff needs to net out a lien. How much really are their past medical expenses? And what will it, and I put in quotes, actually cost for his or her future care? Next slide, please. What damages discovery are we actually talking about concretely? Well, first, get the itemized lien, not just the total, but the breakdown. Get the health insurance files. We want those so we know what the frequency of care is, who is providing the care, and the difference between what is being billed versus what is actually being paid for the care. In the case of a child, for example, we want to get the school records, therapy records, and home health records when applicable. The analysis, the purpose of that is to gain an understanding of the child's actual needs and actual care versus what is likely being put forth in the inflated plaintiff's life care plan. Obtaining information regarding any litigation funding is also important. And frankly, that's a topic of a whole other discussion. But that said, it is happening, and it certainly serves to increase the value. The use of motion practice can also be effective because it illustrates the importance of being aggressive to get those things in discovery that you haven't gotten. Hold the plaintiffs accountable for what they haven't produced. Also consider the strategic use and timing of depositions and IMEs. You know, a lot of people jump to take the plaintiff's depo early, and I get that, but also I think consideration should be given to maybe first getting the medical records, the billing records, and the lien information first. You have to, of course, weigh the pros and cons. And the same consideration should be given to family members. With respect to treating physicians, it's usually better to take that depo before the life care planner, except, of course, if the life care planner claims to have spoken to the treating physician. And with respect to folks like fiduciaries, like guardians, conservators, or trustees, find out if plaintiff is really paying the billed rates. Are they really ignoring the use of available insurance? And are they really investing in bonds? Or are they being more aggressive with how they invest their money? And finally, don't pass on taking expert depos when you can. I know that many of you have taken the same depo of the same expert time and again, but don't discount the possibility that you might learn something, that it might be an opportunity to chip away and get new sound bites or new ideas to undermine their position. I'm going to very quickly just go through some examples, and next slide, please, of some depositions just to give you some concrete kind of little fun, little sound bites. This is an example of a family member's deposition, and it serves to illustrate the point that the family member preferred direct hire over agency hire for a home health aide, which is far more expensive. The family clearly wanted a single provider rather than a revolving door of caregivers. So just very briefly, we look at this. Here it says, is the family currently using any other help or agencies? And the answer is no. Sue is the only one that comes now. And what's the reason that you're not using the agencies? They just didn't work out for one reason or another, and it's very expensive. And you can see, if you can continue on in the deposition, this family only wants Sue. Next slide, please. Here's a good example of an actual case to illustrate why we ask these types of questions, because it has the greatest impact on the price. And you can see it right here. Before we were involved in this case, both the plaintiff and the defendant had used agency rates. But as you can see in this example involving a 62-year-old female who suffered a stroke and required 24/7 care, the cost of direct hire, even for an additional 21 years, was a fraction of agency rates. Next slide, please. This deposition illustrates the importance of deposing treating physicians. You might be surprised, but they don't always give favorable testimony. This is actually a very humorous deposition. In this case, the plaintiff claimed that she needed all sorts of things because of a hand injury, and the treating physician, however, just dispelled that notion. Rather than me reading this deposition, frankly, this treating physician said no to many of the things she claimed she need, and in the end, the treating physician said, and I quote, "I think I need a life plan evaluation." Next slide, please. And finally, this is a sample of a life care planner's deposition. Here, the life care planner admitted that in the real world, when she's hired as a case manager, as opposed to an expert, she said that she would consider the use of health insurance. She would consider related costs and how things are actually paid for. But as a life care planner, she doesn't do any of those things. And you can see it here in her deposition at the end. She's asked, did you make any effort to determine the cost of health insurance for the plaintiff? No, that's not typically part of a life care plan, and I was not asked to do that. And then she's asked to clarify the scenario. And in the end, she admits, if he was coming to me as a case manager, then yes, she would consider those things, but not as a life care planner. I'm now going to turn the program over to, I can see on the screen here, I think they're asking for a poll if you folks can answer that question. And I'm going to be handing the program over to my partner, Richard Montes.
Thanks, Karen, and thanks everyone for joining us this afternoon. So to continue on Karen's conversation about damages and rethinking our damages experts, I mean, when we think about what we've been doing for the last couple of years, we've been playing on the plaintiff's playing field. They created the life care planning industry. It's not a pejorative statement, it's a fact. The original founder of life care planning came together with a plaintiff's attorney, and they developed this idea. And actually, towards the end of his career, he actually expressed his regret at the direction that the industry had gone and started doing more defense work because he felt like the industry had taken on a new approach that he just didn't, that he had never intended. It sort of got away from him, maybe much like Facebook did. He regretted what he had created. But the life care planning industry is a made-up industry. It does not exist in the real world. Many of the life care planners don't actually care or follow any of the patients that they take care of, or that they're not patients of theirs. They're the plaintiffs that they are writing plans for. And there's no data or statistics that show the reliability of life care planning. In fact, there are, I think there's a bid out right now to do such a study because a lot of these questions have been asked. But in the end, there's no science to life care planning. And when you think about what life care planning is when an individual who has most of the time no degree in medicine comes in and tells the jury two things. One, what medical needs there are, and two, the cost. Well, if a life care planner is not a doctor, a life care planner cannot tell you what's medically necessary. And in fact, most often they're talking with a doctor. They're talking with a physiatrist. They're talking with the treating physicians because they cannot tell you what's medically necessary. So why would we need a life care planner when we could just go to the doctors themselves? The second thing they do is tell you about cost. But where are they getting their costs from? Many of them are getting their costs from picking up a phone and calling a number of providers. Sometimes they're calling one person, which is not a statistically significant sample size. Life care planning says to do at least 3. Many of them don't. But even 3, is questionable as whether or not that eliminates all outliers. But in the end, they're still just picking up a phone, which is no different than what any of us can do. Or they're looking at a book they never compiled, a book that some states and some courts, including Illinois in the last year or so, one book that is often used, a book called Fair Health, which compiles data on charges and not paid amounts, but what's charged by physicians. They're looking in that book and they're deciding, well, I'm just going to use this percentile. That again does not take any expertise whatsoever. And in fact, the life care planning industry recently had a conference where the biggest question at the conference was, how should we be pricing life care plans? So they themselves do not have a consensus. I think the reason that they had that conference was because of some of these recent decisions and the reliance for most of them on fair health. The reality is that they're not doing anything scientific. So what we need to do is we need to rethink who we're coming in with. If that industry is a bogus made up industry, why are we coming back with a bogus made up response? And the reality is that most of us don't want to put up our own life care planner at trial because we don't believe they'll hold up. We don't believe they have the credibility to make it to the end. And that's what we need to rethink. We need to be able to come into cases, put on experts who we believe can go in front of a jury and make an impact, who can provide a credible response to what the plaintiff's plan is. And we don't need that person to address every single issue. We need them to be able to, as Karen said, target the main issues in the life care plan. Aside from life care plans, then we have the present value analysis, which if you think about the present value analysis, it's really the gasoline that goes on top of the fire that's already there. Many economists nowadays from the plaintiff side are doing something called net negative discounting, which means that they're not actually making the number less, they're making it more. We had a case recently where if you took the life care plan and added it up over life expectancy, the number was 50 million. The Economists came into the case and said, well, for that 50 million, you actually need $220 million today to fund the 50 million that he'll need in the future. We filed some motions, and that opinion was knocked out and not admitted at trial. But that is happening with regularity in cases. So what should we be doing on present value? Can we think about it differently? Can we be putting in annuity evidence? Or can we look at how money is actually going to be invested? A traditional economist comes into a case and says, you're going to invest 100% in bonds, but nobody invests 100% in bonds. No reasonable person with their money is going to say for the next 50 years, because first of all, they can't buy a bond that will cover 50 years, but no one's going to take 100% of their money and stick it in a bond, especially if that bond is losing money or that investment is losing money every year for the next 50 years. So let's look at how money is actually invested. We can go to the next slide, Rachel. And this is just an example of how big of a difference a traditional present value approach that we would get from our traditional economists is in comparison to an investment analysis that looks at how money will actually be invested in the real world. And why is this significant? This is significant for two reasons. Number one, it does help you with presenting a lower number, which not only allows you to have a lower number for your analysis, but lowers their ceiling. And that's the key, as Karen said, we want to lower their ceiling so that we can anchor the number lower, anchor the brackets lower. But it's also important because they often, and let's think of a child case, children who are catastrophically injured need to put their money into a trust, or anybody who's no longer able to control their own finances needs to put their money in a trust or have a fiduciary manage the money. That fiduciary is bound by the Uniform Prudent Investor Act, which has been adopted in almost every state, not every state, but almost every state. And those fiduciaries have to invest in a diversified portfolio. They can't invest in bonds only. And so if we're looking at the real world and how money actually is invested, you would be able to present an expert who can explain that if I wanted to today have $50 million, or I knew it was going to cost me $50 million in the future, then today I need this amount of money, which I can invest. Robert Tyson in his book actually mentioned this as an interesting approach when you're thinking about non-economic damages. How much would it cost to invest? Well, we can actually have that expert do it on the economic side, and you can maybe build off of that as well on your non-economic side. Next slide, please. So what Karen and I do, Karen and I's background is in appellate practice. We're with the largest firm in the Northeast that handles appeals and litigation strategy. And we came into this project of looking at damages from our appellate experience and thinking about why not only are we seeing cases where courts are telling us we can't do anything on the number because defense didn't put on a damages defense, but also what are all these barriers to being able to demonstrate to a jury what is really going to happen when the case is over. And the biggest impediment is the collateral source rule. And the collateral source rule, as many of you know, prohibits us from presenting evidence of insurance at trial, being able to talk about the benefits received, maybe even be preventing us from talking about the difference between what's billed and what's paid. And part of what Karen and I have been working on with others throughout the country is to not only have the aggressive defense on damages, which if we take it all the way to the end, we want to be able to have, but creating opportunities to challenge the law as it currently exists, circumvent the law as it currently exists, or expand in areas where the defense has been successful through motion practice, through laying the foundation, through additional and new experts. And certainly the collateral source rule has been one of those areas. We can go to the next slide. Prior to President Trump coming into office, there was a lot of discussion about the Affordable Care Act and whether that changed the landscape and our ability to talk about these issues. And Karen and I had made success in various parts, including in California, on this issue. And then once Trump came into office, things kind of fizzled out, I think. The motivation, the interest in doing it, there were more adverse rulings. The thought was that the ACA would go away and that many of these arguments would be no longer successful. Here we are several years later now, almost, I think, 10 years beyond when the ACA was enacted, and it's still here. And it's still the law of the land. And it still has had and continues to have an impact on medical care, medical expenses, and the medical industry. And so now the question is shouldn't we be looking at this again? Should we be coming back to these arguments about what is available through insurance? Now, even if you can't win at trial, these arguments are all still helpful during mediation and as you talk about cases, because you can demonstrate how certain amounts of money might be sufficient to cover an individual's future care needs if they take into consideration insurance. So all of this is still worthwhile to bring into your cases so that you can understand or be able to present and anchor in different ways. The key, though, of the, let's call it the Affordable Care Act argument, is understanding where it's helpful and understanding where it's not helpful or maybe less impactful. In the beginning, when it came out, I think most people thought it was a panacea and it would just knock down everything. And the only thing that the defense would have to pay for is out-of-pocket costs. That was incorrect. That there was a Holy Cross article, I think, that sort of started that concept. And the truth is that it is still beneficial. It is still helpful, but it's helpful in specific cases. It's helpful in prosthetics cases, orthopedic cases, medication, hospitalization kind of cases, but it's not helpful where Medicare is involved. If you have a case where an individual is on Medicare, while some will tell you you can have both private health insurance and Medicare, the reality is that that's not guaranteed that you can do that. And more often than not, they won't sell you a private policy if you have Medicare. It's also not going to be as impactful in cases involving home care, where home care is the primary component of a life care plan. Most private health insurance policies do not cover home care. Well, although the caveat to that is you have to check, because there are some states where the plan, the benchmark plan in that state does actually permit coverage for private home health care. And sometimes that home health care is the more skilled health care from a nurse and an LPN or an RN, as opposed to the kind of health care that would be provided by a home health aide. So you do need to look at that. Next slide. So this is just an example of a case that we had where we did wind up going through and line by line looked at what in the life care plan was covered and what was not covered by the insurance plan in that state. And every state has had to adopt a benchmark health plan. That benchmark health plan tells you the minimum amount of coverage that needs to be provided by every health insurance plan in that state. So instead of having to say, well, this particular plan will provide this and this level of care, as long as it's consistent with the benchmark plan, which it has to be, we could say with reasonable certainty that this individual, whether it's this plan or another plan, is going to have that covered. And in this particular instance, we were able to knock out or reduce the vast majority of the items in the life care plan that were covered by health insurance. We can go to the next slide. This slide, I want to talk about the combination of insurance and Medicaid, but also looking and utilizing resources that are available out in the public sphere and also within a case, and how you can use that and capitalize on it. So while normally, as I said before, it'd be very difficult to make an Affordable Care Act argument, a private health insurance argument in a high value case involving home care, the truth is that you can combine private health insurance and Medicaid. Earlier, I said you can't do private health insurance and Medicare. That's correct. This is now Medicaid, and you can. And actually, according to California's Covered Cal website, you can as well. There's also a plaintiff publication that we came across where a special needs trust attorney also said that you can have both private health insurance and Medicaid at the same time. So here we were in a case out in California involving an infant in a medical malpractice case where insurance, private health insurance, is admissible under their statute for medical malpractice cases. And we were able to make an argument that this individual can have both private insurance and Medi-Cal. The other thing that they did, though, is that they opened the door, or as we argued, to a full discussion on Medicaid because they included within their life care plan a fiduciary and a conservator. And according to the California Conservator Handbook, you must make every attempt to obtain health insurance for a conservatee. So what we suggested and recommended in that case is, let's cross-examine, or let's take the deposition of their expert or their fiduciary, their conservator. Let's confront them with the California Conservator Handbook. Isn't that, if you're going to ask in your life care plan for us as defendants to pay for a fiduciary and conservator, don't we then have the right to ask, well, what is that person going to do for you? What is their job? What is their role? And if that duty and obligation includes health insurance, we should be allowed to talk about it. You're also going to see this same kind of argument with case managers. Almost every catastrophic injury life care plan has within it case managers. If you look at the duties of case management, the principles of case management, the standards of case management as put out by their groups, those include the same thing: to understand, be aware of, and assist with health insurance. So again, if you're asking me to pay for somebody in a life care plan, shouldn't I be allowed to ask what that person is going to do? And the remarkable thing, as Karen pointed out in one of the earlier slides in the deposition, was one of the life care planners was in fact a case manager. And so in follow-up depositions, we've asked, so in your role as a case manager, you would do all of these things, correct? But in your life care plan, you don't mention any of them. Why is that? Because the life care planning industry, which created life care plans primarily for plaintiffs, has decided they don't do that. And that's why they don't do it. And so if we can get past that veil, if we can move past that, get into use their plans, the information within them to ask these questions, we can begin to lay the foundation for chipping away at it. Are we going to win every motion? No. Are we going to win every argument? No. But each step, we make incremental progress, and we've seen that over time. We can go to the next slide. So if you're running into if you're in a strict collateral source rule state, we know we're going to have trouble getting past the trial judge on the difference between what's billed and what's paid. So how can you, aside from going right at the collateral source rule, how can you, from a legal standpoint, try to navigate around it? And the way to navigate around it, or the one that we've used that's been successful so far, is to not argue, here's what plaintiff paid through their insurance. But here's a measure, a methodology of what people pay in the marketplace. Here's a way in which it's been recognized that individuals can try to determine what the market value is. And market value, if you think about definition, if you think about reasonable value, the reasonable value of something is not what an individual unilaterally declares as their value. The reasonable value of something is what people are willing to buy in exchange for. And so I often use the example, I could tell everybody I'm a $1,000 an hour attorney, but if nobody pays me $1,000 an hour, that is not my value. The value of my services is what people buy in exchange their services for. So if we could provide that definition, that gives us an alternative way of getting in. We can go to the next slide. Just to show, even on a lower level, $630,000 life care plan, how you can utilize and build upon each of these arguments. We could start to lower their ceiling. The reasonable value of $630,000, significantly less. And then from there, we can eliminate other items. You don't need future surgery. That's not in any of the medical records. You don't need a CAT scan. It's not in any of the medical records. You have several pre-existing injuries, and you continue to chip away and lower their ceiling. Next slide, please. So as Karen said earlier, the key to successful damages defense is early assessment and early development, laying the foundation through discovery, depositions, setting everything up for motions, and recognizing that the plaintiff's anchoring begins with voir dire. It doesn't begin at trial. They start right off the bat at voir dire. So develop your comprehensive and targeted damages strategy. Pick out the individual items of the plan that we expect are the largest drivers, or the ones that we can challenge most directly. Retain the right experts. And then when you retain experts, don't just look at the list that's being passed around. Hey, these are the names that I'm seeing that a lot of people are using. Make sure that their testimony is going to be consistent with each other. Make sure they're the right fit for the case, and make sure that they're able to present the most credible damages alternative in opposition to what we're receiving from the plaintiff. And then we need to start testing and refining our damages strategies. So we've done all this legwork. We've gotten all this information. We've been able to present and new experts. We've been able to lower our number. How then do we win the number at trial? Now, the goal is to not just beat the number. The goal is to win on liability. But with numbers going up so much, with settlement values going up so much, with nuclear verdicts going up so much, and plaintiffs holding out longer and longer, there may come a point in time where their demand is just too high to settle. So we may have to try more cases. And if we're going to try more cases, then another way to win is to beat their number. So we have to also think about, as Bob Tyson writes in his book, how do you credibly present numbers? How do we offer those counter numbers? And how do we use focus groups, companies like Magna, to help us figure out how best to present those? You go to the next slide. There's another poll question. And so, consistent with what I said a moment ago, these trials that were delayed because of COVID have started up, and have started up sort of scattershot now too. I mean, what we're seeing is some judges are just randomly picking cases that weren't even trial ready and sending them out. And so right now we're seeing a flood of cases that are sort of surprises and others that were on the docket. You have to look beyond and start thinking about which cases are coming up and whether or not there's an opportunity and time to implement these strategies, but also whether there's time to refine and test your damages strategy before trial. And with that, I'll turn it back to Rachel.
You're on mute, Rachel.
Yep, thank you very much. I couldn't get my controls to pop back up, and instead I was flying through the slides here. Thank you so much, Karen and Richard. Really sound advice about changing the game and sort of taking control, becoming more proactive with the defense approach to damages from the beginning of the case, allowing more opportunities to cut down what the plaintiff's anchor eventually will be to the jury. I think that's the key point here, that we want to do everything that we can to force the plaintiff into a lower anchor by doing that work ahead of time and minimizing at least the economic damages. There have been a couple of chats about plaintiff requests for non-economic damages and pain and suffering. We know that juries do consider the economic damages when they're thinking about pain and suffering, and often there is a proportional relationship between non-economics and economics, which I'll share in a couple of moments. But to the extent you can whittle down those economics, it is going to help mitigate or temper somewhat the high anchor that the plaintiff can put out. So we've hopefully answered the question that I've got here on the screen for you all by this point. The damages anchor is a psychological effect that hearing a large number from the plaintiff is going to have on juries. And this applies outside of litigation. It's just the concept that when people hear numbers, that becomes the context through which they're going to think about subsequent numbers. I'm seeing more and more that plaintiff counsel are even mentioning their potential damages request in voir dire, either a specific number or saying something like, I'm going to ask for tens of millions of dollars, so that they give themselves a little wiggle room and not put a pin on it. But they want jurors thinking about the case in terms of tens of millions of dollars, for example, so that when they only ask for 10 or 9, because jurors have been thinking up in terms of that high anchor, the number requested seems more reasonable. Now, we've been talking about how to go about developing the defendant's own position and own counterfigure on damages. I hopefully you've guessed by now that our position is more often than not, the strategy should be, you need to be putting forth this counterfigure. The plaintiff is anchoring jurors high, and defendants need to be anchoring jurors low. Jurors struggle to come up with the appropriate damages figure. We often hear jurors say things like, well, the plaintiff has asked for too much. their number's not realistic, but I don't know what to do otherwise. And that's particularly the case with non-economics, where there's no set formula, there's no receipt that jurors can use to come up with that number. So I want to share with you an example of a mock jury. This is an online mock jury discussing damages in a case, and they're trying to figure out, well, what would be appropriate for us to award. And they discuss the fact that they feel they don't have any guidance from the defense. So let's hear what they have to say.
So what about go ahead. They did hire the actuary or the medical economist to extrapolate that. Well, we got that from the plaintiff, but we got nothing from the defendant, because the defendant, I imagine, doesn't agree that they owe it. So, I would say, if they don't agree, would they not have proposed a different number? They don't agree that they're responsible for future members. I think their number is 0. Yeah, they think their number is 0. So they don't want anything. So I guess I've got to, if I had to vote, I would have to vote with the plaintiff on what the future medical bills would be.
So you hear the one juror say, well, if the defense lawyer disagreed, wouldn't they have given us their own numbers? And everyone else says, well, no, they didn't give us numbers because they don't think they're liable. Clearly, this jury had already decided the defendant was liable. They were going to award something, even though they didn't necessarily want to agree with the plaintiff's figures. Juror Fred there says, well, I guess I'd have to go with the plaintiff asked for. They really look for guidance from the attorneys and from your experts as to what should the numbers be that they're considering. Jurors in their mock deliberations consistently say things like, I'm not an expert in this. I don't know how to value someone's life or someone's future care needs. So it is incumbent upon you as the attorney to give them the tools that they need to make informed decisions. Fred here clearly didn't want to go with that plaintiff's number, but said, I guess that's what I just have to go with. And we also hear more and more plaintiff attorneys taking advantage of defendants who don't put forth a counterfigure by saying, you didn't hear defense counsel argue with my numbers. I told you what the numbers are, what our experts came up with, and what I think is appropriate for non-economics in states in which plaintiff lawyers can do that. And they didn't argue with my numbers. So there you have it, ladies and gentlemen, and juries do consider that. I mentioned at the top of the presentation that one of the major concerns, the major hesitancies that defense counsel have in putting forth a number is that, don't I walk into a plaintiff verdict by, quote, offering money? I'm arguing we have no liability. I'm arguing it should be 0. And then I put forth this number. Doesn't that tell a jury that, in fact, I don't believe it's a 0 and I'm accepting responsibility on behalf of my client and we're offering to pay? There has been academic research on this exact issue. For example, a study published in 2016 looked at whether the defendant contesting liability offering a counterfigure impacted participants' assessments of liability. They found that it didn't, meaning they were not more likely to get a plaintiff verdict when the defendant offered a counterfigure versus when they did not. However, it did reduce the overall damages award by 43% over when the defendant simply ignored damages, and even more over attacking the plaintiff's number, saying that's not appropriate, but then not offering their own. Another study showed that the counterfigure put forth by a defendant didn't affect either liability or damages. And then a third study also confirmed that a low defense anchor ultimately reduces jury awards, but does not increase the chances of a plaintiff verdict altogether. I want to share with you all a few examples from our own jury research beyond the academic research. We've had a lot of instances where we might use different research methodology on the same case. So we're testing the case more than once. To Richard's point, we're trying to figure out what's the counterfigure that is most appropriate here, and what are our strengths and weaknesses, both in terms of liability and damages. So we will sometimes run jury evaluators, which are surveys, jury confirms, which are online focus groups, and or an in-person focus group or mock trial in the same case. Now, I'm going to fly through these pretty quickly keeping an eye on the time, but I wanted to share with you, these are just a few of the examples of cases in which we've run jury research in one example, and not put forth a counterfigure in one study. And then in a subsequent study, we did put forth a counterfigure from the defense. And you can see that there are significant decreases in the amount of damages that jurors awarded in the same case. So what you're seeing here in gray is a jury research study in which the plaintiff puts forth their request, defense says it's a 0, and then in orange, you're seeing the same case tried in which the plaintiff puts forth their request. The defendant says, that's not a reasonable number. Here's our counterfigure. You can see that the amount of money actually awarded on average by these juries is substantially lower. And you'll see this consistent pattern as I flip through more and more examples. So here on the left, you're seeing we did a survey in which the plaintiff requested 95 million and the defense did not put forth another anchor. They said it's 0, we contest liability. The average damages award was 67 million. We then did a focus group in the same case. In that instance, the plaintiff's request went up to 130 million. The defense anchor put forth was 19 million and the average award was $22 million, much closer to that low defense anchor. Similar situation here, plaintiff's request versus the actual awards being much closer to that defense anchor. And I apologize, the defense anchor here should be $1 million in the right column. So a 96% decrease off of what plaintiff requested and much closer to that defense anchor. Again, initial survey, plaintiff's request with no defense anchor resulted in an average of about 95 million in damages. On the right, same case, plaintiff's request goes up, defense anchor is 19 million, average award 29.6. So you can see in these anecdotal examples, the real concrete effect of the defendant giving the jurors the tools that they need, those alternative numbers to consider and use as an anchor from which to work their way up to an appropriate award versus using the plaintiff's anchor, the only number they would have heard, to work their way down from. Sometimes jurors will say things like, gosh, $100 million, that's obscene. I'll never award that. But what should we award? And they'll do something like cutting the plaintiff's request in half. And now they've awarded 50 million, but they think they've done you, defense counsel, a favor because they slashed plaintiff's request in half. Little do they know that that's not a favor at all. However, they might hear from you in that same case, a proposed counterfigure of, let's say, 5 million. They say, well, that's probably a little too low. Let's double it. So they're working their way up. Ultimately, that results in a $10 million award versus the 50 million. So even though we know jurors are going to work their way up from our low anchor, the point is that when they work their way up, they end at a much lower number than if they're working their way down. The clip that I have here, I'm actually going to skip it for time purposes. This is a mock juror talking about how the jury should approach non-economic damages. And I mentioned to you that those considerations are often proportionate to economics. And this gentleman here advocates for matching, he says, at least what they awarded for the medicals. So they'd awarded a substantial sum in this case for medicals, past and future. And he says, we've got to give at least that for the pain and suffering. That goes back to Karen and Richard's points. If you can get those medicals down and the future life care plan down, then matching that for non-economics is only going to help. So when you're considering what your low anchor should be, these are some points that we recommend keeping in mind. Think about bringing down the economics, but also not ignoring non-economics. It can be tempting to leave those non-economics sort of floating out there. In some states, plaintiff counsel can't put forth a specific request for non-economics, but in many states they can. When defense counsel ignores that, jurors struggle with, well, what does make more sense? They need that guidance. So don't be afraid to address and provide anchors for both economics and non-economics. Show your work is a key recommendation. What do I mean by that? Jurors don't want to just hear a defense counsel pull some low number out of a hat. $1 million. Jurors say, well, they just came up with that out of nowhere because they needed to give us a low figure that's not offensive. How did they get to $1 million? Show them how you got there. The jurors want to see that you actually took a reasoned approach, that there are calculations, that you relied on an expert, for example, that you thought this through. And in addition to showing them with your words, we want to use visuals to the extent possible. I always love sharing this, that people remember, they retain significantly more of what you both show and tell them versus what you're just showing them or what you're just telling them. So if you want jurors to remember your anchor, put it in front of them in writing, let them see it, let them see your calculations and highlight that ultimate figure. Of course, you want to be reasonable. You don't want to put forth a number that is so low in consideration of what this plaintiff actually did experience that jurors are offended and say, well, now I'm upset. Now I'm angry that they'd have the nerve to tell me this person's life is only worth $100,000. And now my verdict becomes punitive. So be careful about that and make the figures meaningful to jurors. This ties into showing your work. It has to have substance behind it for a jury to really consider your figures. Otherwise, they're going to treat your anchor like monopoly money, just like they treat the plaintiff's anchor. So it is most helpful to tie your damages arguments into your overall defense theme and not treat damages like a completely separate animal. It should be one cohesive presentation. So when do you start thinking about anchoring? Karen and Richard covered this. You want to start thinking about it from the get-go. In discovery, start thinking about what makes most sense. Approach mediation with your anchor already developed. As early as voir dire, you want to mention to the jurors that plaintiffs just told you they're going to ask for tens of millions. I'm contesting liability and I expect the evidence will show why my client's not at fault. However, I'm going to have to address those numbers. And who thinks they're going to hold it against me that I have to address the numbers as a defense attorney? Talk about it. Let the jurors know that this is coming so that they're not surprised and you don't lose credibility later. You want to address numbers to the extent you can with your experts and of course in your closing, but closing should not be the first time that you are thinking about and presenting your anchor to that jury. So in conclusion, don't wait. The defense can anchor too. You need to start thinking about it now. This is not just a tool for plaintiffs. It's a tool that the defense bar can start taking advantage of. Challenge the plaintiff's model. Rethink the experts that you are hiring. Don't forget the visuals so that jurors remember those numbers you're giving them. And don't forget to test your counterfigure. You've come up with what you think works. It's important to run that by some mock jurors and find out how they react. Is the anchor too low, too high, just right? Are the reasons that you're providing for that anchor appealing to a jury? So I'm going to stop there. We've got one final poll on the screen and we've got just a couple of minutes for questions. Karen and Richard, I don't know if you've had any opportunity to look at some of those chats that have been coming in. But if you have, I welcome any thoughts you have to address some of these questions.
And so one of the questions that was asked was about past medicals and sort of a trend of plaintiff attorneys not putting in past medical expenses. And how do you respond to that? I think it's a case-by-case situation. And if the opportunity is there, where it would be useful for you to refer to the past meds, just because the plaintiff doesn't put it in doesn't mean the defense can't refer to it. Doesn't mean that defense can't rely on it. Doesn't mean that defense can't ask about it. And doesn't mean that you can't in some ways incorporate it into your analysis if it's beneficial to you. And so I think the knee-jerk reaction typically is if they're going to stipulate, I'm going to stipulate. On the other hand, you may not want to. You may want to be able to utilize it to your advantage.
I think that's a great point. I want to just give a heads up for everyone that needs to jump off at the top of the hour. Richard, Karen, and I will be happy to stay on and address some of these additional questions. So if you'd like to stay, please do. If you need to jump off, we will be posting the recording of the webinar on Magna's website and social media. We will also share the PDF of the slides that we used today. I'm happy to drop a PDF of those into the chat. So again, if you have to run, you can get in touch with us to get these materials at a later point. And Richard and Karen, while I am getting this PDF uploaded, again, if you had any other comments in response to the questions, feel free.
Sure. I think one of the questions that we've seen a couple of times now is this was a heavily personal injury focused presentation primarily, but do some of these concepts translate to other areas of law? And the answer is yes. I mean, if you go through Rachel's last few slides, in particular about sort of the considerations when anchoring, the truth is that we are not at a point now yet as a defense bar where we have the answer to how do you best present a pain and suffering number? How do you best present a counter number for different types of damages? We have principles and concepts, and those are the ones that Rachel set out. And I think those are the concepts that certainly translate to any type of case. So show your work, be reasonable, be careful with boomerang effects. Make sure you use figures that are meaningful to the jurors and test them. You should have the opportunity to test if you know your case is coming up and you think it's a high value case. You should look to test as many of these issues and themes as possible. And you may have to do it more than once. You may need to do the first one to get a generalized sense of how people are reacting, and then do a second one to hone and refine your strategy.
No, Richard, you raise a good point, and we were talking about this earlier, and I don't mean to put you on the spot with the story, but you can go in thinking that it's going to be, the data is going to be interpreted one way, and then you go to a focus group only to find out that it's not the way you thought it was going to be at all. And sometimes it takes the repackaging of the information to understand, what another perspective might be. You want to give it, I don't mean to put you on the spot,
Yeah.
but I'm sure you have a good example of that.
Yeah, I mean, the best example I have actually came from a client of ours. They did a focus group in a case involving a sexual assault at a school. And there's been sort of a pervasive concept among defense attorneys that one of the things you do is try to tie pain and suffering to a specific event, leisure activity, something that the person would do. It appears in Tyson's book, but this is not a criticism of Bob at all. It's really more relevant to the case, to this particular case. But can you use that? So in other words, what they particularly tried to do is how many trips to Disneyland would it be to get to the plaintiff's number? And that's what defense counsel did. Well, this would be the equivalent of X number of visits to Disneyland. And in the focus group, the jurors were completely offended by it. They didn't like it. They hated it. But what was better was they gave their own example of what they thought would have been more effective.
Because it was a sexual abuse case. I guess we should stress that. It might have worked in another case, but they were offended in the context of this fact pattern.
Right. But it was like, if you're at the school and you let this happen, why are you talking about trips to Disney World? Right. Maybe that wasn't the best example to use for that particular case. And what they said was, if you had used psychological therapy visits, that would have been a better anchor for us. We would have probably hooked on to that more. And that was just really eye-opening. I think it's very important that theoretically there's a lot of different ideas that we could use, but you really do have to match it to your case. And you really have to think about how it might work for your particular set of facts and the types of jurors that you're going to get.
Yeah, I wanted to underscore that point, that I wish there was a magic number that we could say, to address, for example, Victor asked a question, what about for wrongful death? What's a good anchor? You would think that we'd be able to say, well, for wrongful death, it's $1 million. It's very dependent on the specifics of that case, the defendant's conduct, how angry do we think jurors may be or not? And also, frankly, the characteristics of that plaintiff and the survivors. For example, how emotionally connected are jurors going to be to that particular plaintiff? So it's got to be a decision that's made in the context of all of the other facts in the case. I do find consistently, to Richard's point, that jurors don't like defense counsel to suggest how the plaintiffs could spend their money, like going on a vacation, going to Disney World. For some reason, that really rubs jurors the wrong way, because they think, who are you, Mr. or Ms. Defense Counsel, to tell these people that they should go on a nice vacation, and that takes away their pain. They want, though, what they better resonate with are concrete suggestions to address specifically the damages. So is it therapy? That's often something jurors mention. That's something tangible that you could say, therapy twice a month for the next 30 years equals X number of dollars. And that's what this person needs to help get over this loss or get over the injury. So you're bringing them back to reality by tying pain and suffering to something that's economic, that makes more sense. Like Richard said, they need therapy, or there's something that they that will specifically address, and not seeming like you're dictating how they should spend the money. That's a very good point.
Yeah, and there are different techniques that people use too, which also can be effective, but also still need to be tested. For example, there's a concept called double anchoring. So I'm going to tell you that I could give you two economic numbers. My bottom line number, my best number that our defense experts have come up with is $1 million. But you know what? They made some good points. We missed a number or two here and there. So the real number is 1.5. And here's how I got there. As to Rachel's point, I'm going to show you the work. I'm not just going to arbitrarily, because then it looks like I presented somebody who I never really was going to stand behind to begin with, and I've lost my credibility. But and you may even want your expert to acknowledge, maybe one or two additions to what they did. Well, based on the music therapist who came in, it's not medically necessary, but you know what? If the family thinks it's necessary, if the family thinks it's important, let them have. They should have it. They should definitely have that. It's no big cost to you to say, so my plan should be increased by some amount for that. Those are the areas where, again, diffusing anger along with the credibility to your number is what we're looking to do, as opposed to just coming in with another number. I think plaintiffs get away with unfettered anchors, defense can't. Right, Rachel? I mean, wouldn't you say that that's a fair sort of assessment? They can throw out 100 million, but if we throw out $1 million, they're going to scrutinize our million over their 100 million.
Yeah, exactly. There's a double standard. Karen, it looked like you wanted to chime in.
Well, Rich, you're not using your famous phrase, which I think is very appropriate here, which is the defense has to engage in principled anchoring.
Right.
Yes.
And you're right that, and to your point, the plaintiffs don't seem to have to do that. They can just throw out any number and it's acceptable.
Right. It's a sensitive thing because it's easy to suggest that someone's pain and suffering or the loss of life is worth $100 million. Who's to disagree with that? It is harder to be the one disagreeing and saying someone lost their life or someone had a catastrophic injury, but their pain and suffering is not worth as much as their lawyer wants you to think it is. It's a really tough position for defense counsel to be in. So just throwing a number out there, jurors need more than that. They want to know, what's the principle behind this? Have you really thought it through? And if you give me good reason, I'll latch on to it. Jurors recognize that the verdicts out there are wild. And some of them will say, come on, this is unrealistic. But they want guidance. They say, well, tell me what it should be. You might have noticed in one of the examples I gave, the defense got better results giving a number than they did when they just said plaintiff's numbers no good, but I don't have an alternative for you. Jurors almost feel offended by that. Okay, well, why aren't you doing your job, defense lawyer? Help me. As a juror who has no idea, it's a little bit of that needing the right tools.
And one of the things, and it looks like we still have people hanging with us, so I'm happy to keep going. And I think it's worthwhile raising is the defense needs advocates in the jury room. And I've seen this over and over again. When they're trying to compromise on a number, if you have strong personalities, they'll pull everybody in one of the two directions. They'll pull everyone closer to the plaintiff number, or they'll pull everybody closer to the defense number. And even if you're going to lose on liability, you need that defense advocate. So number one, you need to try to identify potential jurors who could be that defense advocate, who have the principles, who might match a good profile. And you want to identify that profile before you go in. But the second is you need to give them reasons that they can stand on principle. If they're just obstinate, maybe that doesn't bring the group with them. But if they can say, no, they admitted that there's no way, there's no full life expectancy. And so we got to adjust the number. We can't just arbitrarily choose some midpoint. It's got to be based on, and here's why. And I can go back to, and I can point to the testimony. That gives us a better advantage of pulling people in a lower direction if we give them the tools to debate with their fellow jurors or stick to their guns.
Right. You need to give them the words to say, basically, that you need to give. They want to articulate your points. Give them those words to regurgitate in the jury room and give them, phrases and real concrete things that they can remember and repeat. It's not enough for a defense juror to just say, I don't want to award that much. It seems too high. The rest of the group looks at that person with blank stares and says, so what? You're not offering anything for us to talk about. So giving them that ammunition is key. And I will tell you that even defense jurors who argue till the cows come home about no liability, once they give in, once they are convinced by the rest of that jury that this is going to be a plaintiff verdict and we're going to award money, if they don't have that tool, some of those defense jurors will flip and automatically go, well, if it's a plaintiff verdict, I guess we're going with the plaintiff's numbers, because they don't have the alternative. But if you've given them the tool, then they have something to say, and then they have something more to argue about.
And I've seen sometimes, Rachel, some of the more vocal defense-minded liability jurors give the highest numbers.
Yes.
I don't know exactly why that correlates that way. And I don't know if it's a true correlation, but I've certainly seen it where all of a sudden they've, all right, fine, liability. And then, well, I guess you got to give them the full, the full amount.
Right. I think there's a little bit of cognitive dissonance, we call it, that goes on, that if once a juror has to make peace with the fact that this is a plaintiff verdict and they've been arguing for a day that it shouldn't be, then they're all in. Once they make that flip, they can be some of the most generous. Victor's asked a good question a couple of times that I wanted to ask you, Karen and Richard, if you had any thoughts on what types of experts specifically you recommend to counteract lien numbers. Victor was saying, do you recommend that the defense hire similar providers? And I guess Victor's not had the best experiences with medical billing experts.
Yeah. So we tend to use a healthcare economist, which is different from the billing experts. The billing experts tend to use the 80th percentile of the books that are out there. And even those are based on charges and what somebody would be if they were sort of out of network. And so the savings you get is there, but it's not as significant as if you actually looked at what people were truly paying. So we tend to use a healthcare economist to do that. The problem, again, from the defense standpoint, is all of this is relatively new. And, we're kind of trying to build this, but that's why we do a lot of these presentations, because we would love for others to develop experts that we can all, sort of look to before we exhaust the heck out of the people we've been using. And so it really takes, sort of the defense bar coming all together to really identify new experts who can do this and do this in a meaningful and credible way. The other thing to think about with liens is there's new pricing transparency laws that have went into effect for hospitals, at least, and that data is on their website. They're required to list not only the charged amount, but what they also accept as payment from private insurance, Medicaid, and what they get from people who are paying cash or self-payers. And that is another objective data point that you can use that's available to show that not only does the hospital, because by law required to say this, but the hospital is now telling you, we don't get that charged amount. We're getting this amount from all of our cash payers. And that's your true range, not the bill, not the amount on the bill.
Excellent advice. I think that we may have addressed all of the questions that came through the chats. Some of those either Richard or I responded to in the chat. So it looks like we may have everything covered. Someone did ask a question about CLE credit. If you can please reach out to us, we can get you the course info for Florida CLE. That question came to us anonymously. So if you could reach out to anyone here at Magna, you can reach out to me. It's ryork@magnals.com, and I'll make sure you get the information you need for CLE. If anybody else has any other questions, feel free to send them our way. Karen, Richard, any final comments you'd like to make?
No, thank you.
We appreciate everybody's time today.
Thanks, everyone.
Thank you both very much for the content. I think it's, as I said, really important that we're having these discussions, and your insights are invaluable. So thank you so much, Karen and Richard. And thanks for everybody who stuck with us past 5 o'clock Eastern time. I hope everybody has a great rest of your week.